All rise. The Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Harvey L. J., Judge presiding. All persons having business before this court draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Tight quarters up here. Thank you all for being here. It is a great privilege for the 5th DCA to be here. I was fortunate to have sat here twice when I was a member of the 1st DCA, I believe. This is the first trip of the 5th DCA to Clay County, and it means a lot to us. We're thankful not only to the members of the bar, but the litigants that are part of this and the court personnel who were wonderful, which is a recurring theme here in Clay County. And so very thankful to be sitting here today. I have the privilege of also being here with two of my colleagues, Judge Makar, everyone knows. And he and I served for about 7 years together in Tallahassee and came over together to Daytona. So I think his reputation precedes him 6 times over. If you just look on the website and be prepared to read a lot of stuff, because there's a lot of stuff there, important stuff, but certainly a valued colleague, thankful to have him on the panel. And Judge Boatwright, as you may know, longtime trial judge in Putnam County. Thankful for his trial experience, thankful for his dedication there. I learned recently he was also administrative judge, so I've heard all about all those wonderful things. So everyone knows we do have 3 arguments today. The plan is to take a break after the first OA. We'll probably take about 10 minutes after the first oral argument, and then we will resume for the last 2. There is a Clay County Bar event in Orange Park at Club Continental. And I was asked by Ms. Crawford to mention that. In part, it involves us. We're going to be speaking there as part of a Q&A, as well as having Judge McIver and Judge Pratt join us, 2 new members of the 5th DCA. But in addition, perhaps even more important than that, is a celebration of Judge Don Lester. And as everyone knows here, Judge Lester has been a long-serving and perhaps long-suffering at times trial judge, a wonderful lawyer before he was a trial judge, has been on the bench almost 14 years, predominantly in Clay County, to his credit, and I know he matters to this county. I know his reputation and work product precede him, but as I understand it from Ms. Crawford, that's going to be a feature of the program, and that will take place around noon today at Club Continental. All that said, are the litigants ready for the first oral argument? And for the record, the first case today is Ocala Heart Clinic versus Prashad et al. Case number 22-1272. Is counsel for the appellant prepared to go forward?
Yes, Your Honor.
You may proceed. And would you like to reserve any time for rebuttal?
Yes, I'd like to reserve 5 minutes if that's possible, but in the past I've run over that in case there's an issue that's on the table. My name is Michael Riemenschneider. I'm an attorney from Melbourne, Florida. I'm here with my partner Jeff DeRozier. I'm a civil trial lawyer. Have been in Brevard County for 35 years. This is our first trip up to Clay County. This is our first trip. I have never been to the first DCA. Haven't been up to this area since I've started. So this is a welcome change for me. First issue I wanted to cover in the brief was count 1, which is the defamation per se count. And in that particular instance, the judge, in his order, found that there was a qualified privilege to the defamation, which was for the parties' senses, they agreed or conceded that it was a defamatory statement so that they could argue the qualified privilege. The qualified privilege that was argued had not been alleged in the answer in affirmative defenses. That's one issue.
Well, let me ask you about that, if I may. And I think we all understand that defenses need to be pleaded,
Yes.
Especially defenses to defamation per se. There was a defense of qualified immunity here, and it references this, judge understands it, to Thomas. So why was that not a good enough thing to preserve this defense?
Well, because from my perspective, Your Honor, and I have the affirmative defenses in front of me, it was the second separate and distinct defense, and it cited at the end of the paragraph, at the end of the affirmative defense, the Thomas versus Tampa Bay Downs case, meaning to me anyway that was the qualified privilege that they were going under that particular affirmative defense, the Thomas case, which the Thomas case is not the qualified privilege that the judge decided the summary judgment on. The Thomas case has to do with an employee who has a duty to report to his employer anything of an untoward nature. And so
does Thomas talk about the qualified privilege?
It does. It does talk about that qualified privilege.
Was there a motion filed to that defense, a motion for more definite statement, a motion to strike that defense as being inadequate?
There really wasn't, Judge, because I think that that particular defense with that citation of Thomas v. Tampa Bay Downs is perfectly okay to cite that particular qualified privilege. I did not have any motion practice related to that particular defense because I think that defense is well played. It was
so. Why make the argument that it was well played?
Well, because they pled a number of affirmative defenses that dealt with a number of qualified privileges, and this Thomas one dealt with an employee reporting to his employer. The other one dealt with accountants. In some states, accountants have a qualified privilege if they report to their employer. We don't have that here in Florida, and they made that affirmative defense as well. They did not make any affirmative defense based upon the Fritovich case or the Delmonico case, and they did not cite either one of those cases as being the case that they were going to argue in front of the judge on.
So you go to the hearing on the motion for summary judgment. Did you tell the judge that it was your position, your client's position, that the defense was improperly pleaded?
No.
Why is that not way?
I raised the issue. The judge came back with his summary judgment, and he asked for objections. And I made that, he asked specifically for objections to his summary judgment, and I made that argument at that time. And so the judge had us brief that issue, and then the judge decided against us and entered a final judgment as to the claim.
Was it argued at the hearing by the appellees?
It was argued at the hearing, yes. That's my recollection. That issue was brief. In fact, the judge heard the argument and said, I want briefs on this issue. Then we briefed it, and then the judge just decided without any comment that he would go ahead and enter the final judgment. So, getting back to count one, let's assume it was properly pleaded. I think that there's a problem anyway with count one because count one, I think the court really kind of stretched the Fritovich case a little bit beyond what Fritovich really stands for. And he doesn't mention the Delmonico case, but it seems as though Delmonico is part of his decision making. But he just mentions Fritovich. And Fritovich deals solely with the issue of a individual speaking to the police or the state attorney and defame someone during that particular conversation to the state or to the attorney, or for the state attorney or for the police, of a claim or an indictment that's not been made yet or an information that hasn't been filed yet. So there's no case pending at the time this criminal complaint is made. So therefore, Fridovich and its progeny, cases that came after Fridovich, are very specific on the fact that they deal with criminal cases and they deal with specifically this privilege of an individual talking to a state attorney or a police officer and making defamatory statements. Now,
You would agree, though, that there is a long line of cases dealing with the qualified privilege in a litigation setting.
yes, sir.
And it doesn't have to be a criminal
Yes, sir.
litigation.
Yes, sir. I think
So why would those cases not apply to the court's analysis in this case?
Well, I think the Delmonico case is the case that really deals with the issue. And Delmonico dealt with an attorney who is outside of court talking to a witness in a case that was pending at the time. And in Delmonico, the Supreme Court is very careful to say this is a narrow privilege. And this privilege, or this qualified privilege, and it goes on several times and says many times in the case, this deals with attorneys talking to witnesses or potential witnesses and making defamatory statements. And it has to do with the litigation that's pending, and the discussion has to be connected to or relevant to the lawsuit that's pending. The problem I had with Delmonico in this case is, first, this wasn't an attorney, this was a fraud examiner who was not having an interview, which is the Delmonico was an interview. She sent an email to a vendor of Ocala Hearts, and she did not have a conversation. She just sent this, what we think is a defamatory document to them. And the only thing that was pending at the time, and she was raising the issue that there was fraudulent activity based upon what Ocala Heart had done. And the case that was pending was simply a 605.0411 case where there was a request for documents. And there was a document request under that particular statute. So it had nothing to do with fraud, that particular case. So
What's the status of that lawsuit? What's the status of the records lawsuit?
the records lawsuit is, quite frankly, Judge, it's in oblivion. Nothing has happened on that case as far as I know. Since what happened was the case got filed, and this was before my involvement. The case got filed. The lawyer who was representing Ocala Heart agreed to produce the documents. There were documents that were
What lawyer was that?
Excuse me?
Who was the lawyer?
A fellow named John Conciliar. He was with Ray Robinson at that time. And the documents were produced. And then that lawsuit kind of went into a stay fashion. And there really hasn't been, I have never been part of that lawsuit. I've never been a party or a lawyer in that case.
Because what I'm struggling with a little bit is we have a situation where your client, the clinic, has some of the cardiologists, the defendants here.
Yes, sir.
And there's this dispute about money. You all agree to give documents to them, so their CPA, I think she's the CPA, Ketos, okay, so that she can look at your records.
Yes, sir.
And so it was anticipated some level of investigatory activity was going to happen. And this email, as I understand it, it's just this one email, correct?
Correct. Yes, sir.
That was sent out to this one firm.
Correct.
CUC, I guess is the firm.
Vendor. Yes, sir.
To confirm whether that firm had actually issued these invoices.
Correct.
And in that email, she said, stated something to the effect, I'm investigating fraudulent
Activity.
I'm conducting an audit for fraudulent activity. Invoices have been found that have been falsely created and paid for various vendors. Now, she said potentially it would be, right? So the question is only about that one email with that language and whether it was defamatory per se, thereby entitling you to belief of some kind, correct?
Yes, sir.
That's the whole, this whole lawsuit. That's in a nutshell, that's it.
That's it, sir. Yes, it was based upon the one email and what we believe was certain behaviors associated with when there had been a discussion or a
So how quickly was it resolved that in fact those 3 invoices were legitimate? A few days, a week? A month?
It was a little longer than that. I don't know when Ms. Kitos realized that those invoices were actually legitimate, but it took place after we sued Ms. Kitos, and then her lawyer at the time, Mr. Romanek, represented Ms. Kitos, and that was in September. And I believe by January of the following year, we knew that she was of the position that basically that those were legitimate invoices from the vendors, CUC.
The email was sent to the vendor,
Yes, sir.
and only the vendor by Ms. Kitos.
That's correct.
So apparently somehow it got out to other people. So it was not on her watch, so to speak, that it was disseminated beyond.
Well, it wasn't really disseminated to others. It went back to us. I mean, the lady knew from CUC, the vendor, she knew exactly who she was referring to, O'Callaghan, because she recognized the dates of the documents, and
Okay, so it went to them,
and then it came back
to you.
Right.
Didn't go out to anyone else.
No.
Okay. So there was no public defamatory statement. It wasn't made like on posted on the internet website or something like that.
No, sir. I mean, obviously it got attached to pleadings and such, but
And the vendor never stopped doing business with you.
that's correct.
Didn't you all do any business whatsoever
Well,
from that vendor?
as far as we know.
Well, the record shows.
From that vendor, no. No, from that vendor, no. That vendor continues to this day with O'Callaghan.
And the invoices were the vendors, it was those vendors' invoices.
They
It
were.
wasn't like Cal Health's invoices.
Those
correct?
were the CUC vendors' invoices, yes, sir.
And they weren't marked proprietary, were they?
They were not.
Okay, so why are they proprietary?
Well, the non-disclosure agreement says that that documents could be proprietary as long as it is reasonably apparent based on the form and content that OHC, that's O'Callaghan, intends to treat the information as confidential, even if OHC fails to mark the information and reduce it to writing. So there was a provision that allowed for
Why
unmarked.
were they confidential with the other company's invoices?
They were kept confidential by O'Callaghan. I would, obviously that's the argument that the judge made, that sending them back to CUC was really not a problem because they were not confidential to CUC. From my perspective, and what I wrote in the brief is that's not really following what the NDA, the non-disclosure agreement, says. The court should have made it an inquiry into whether O'Callaghan was in fact trying to keep the documents confidential, which in my view they were.
But how could they be confidential vis-a-vis the vendor who generated them? I mean, I'm struggling with that. I mean, you entered this NDA, everyone with the understanding there would be this investigation by Kitos.
Well,
And so documents surely would be a part of that process.
Well, just a slight disagreement with that. The agreement says that for the specific purpose of verifying certain financial calculations, there was no permission or consent in the NDA to sending out any documents to a third party. In fact, it says just the opposite, but it does use the term proprietary information. If you don't make the leap and say, they were kept by O'Callaghan as proprietary information, then you don't get there. But if you think that O'Callaghan could have kept these documents confidential and were keeping them confidential, then you could make the leap and say she was outside of the contract, she was breaching the contract, because she wasn't calculating anything. She was actually contacting a vendor of ours, which was not appropriate and was not really approved by O'Callaghan. The other issue I wanted to touch on, I realize I'm down to under 5 minutes, but is the attorney's fees issue. And that's in the NDA. The attorney's fees issue is at paragraph 10,
So we've only, there's just entitlement at the trial court level on that, correct?
exactly.
So fees, the amount of the fees have not been ordered, correct?
They have not.
So how do we even have jurisdiction to hear that at this point?
Because the court found that there was entitlement in favor of the appellees in this particular case while entering the final judgment. The situation here is that the document itself, the non-disclosure agreement, says specifically that the prevailing party in any proceeding to enforce the terms of this agreement shall be entitled to recover its costs and fees, it goes on to. And in this situation, they were not entitled to their fees because, on the other side of this case, because they didn't enforce anything. They simply sat there and defended themselves from the breach. They were not trying to enforce the action. I filed a case that cited a case from the Middle District, which relies upon a case out of Illinois. It seems to be a case that is directly on point to the issue of enforcement, and they did not try to enforce the NDA. Now, it says prevailing party, but the only way you would have an enforcement of the NDA is if Ocala Hart moved to try and prevent, through an injunction, any sort of action by the Cheetos or the appellees that was improper under the agreement. And so the recipients are the appellees in this case, and they're not entitled under this provision of the attorney's fees to any sort of attorney's fees because they did not try to enforce the non-disclosure.
That's in paragraph 10.
That's in paragraph 10.
So 10B, correct, but doesn't 10A talk about breach of contract?
10A does not talk about breach of contract. It says, accordingly, each recipient agrees that OHC will have the right to obtain an immediate injunction enjoining any breach or threatened breach. So this has to do with action, affirmative action by Ocala Hart, not by the recipients. So the recipients here in this situation are the appellees, and they're not entitled to, under the strict language of the agreement, they're not entitled to fees. So those are the two issues I wanted to touch on. The rest of the time I'll leave for rebuttal. Thanks.
Thank you.
Good morning. May it please the court, Andy Lavin. I represent appellees, cross appellants Prashad, Bast, and McGee. David Romanek, who is here with me, represents appellee, cross appellant Belinda Cheetos, and we'll reserve 3 minutes of our time for Mr. Romanek, depending on how things are going here, but that's sort of the plan. I want to just address certain of the matters that counsel addressed before and start, Judge Boatwright, with your question about paragraph 10A of the NDA with respect to the attorney's fee provision, because counsel didn't read the entire sentence. You asked whether paragraph 10A addresses breach of contract, and the entire sentence of paragraph 10A of remedy says, accordingly, each recipient agrees that OHC will have the right to obtain an immediate injunction enjoining any breach or threatened breach of this agreement. And then what wasn't read is, as well as the right to pursue any and all other rights at law or equity for such a breach. And necessarily, this provision and paragraph 10B, which is a prevailing party attorney's fee provision, it does just that, to suggest that the words prevailing party should be ignored in this contract, and because we were sued and were defendants in a case in which we prevailed, that somehow this agreement, which expressly authorizes the prevailing party to recover attorney's fees, is not applicable, is just inconsistent with the law.
What about Judge Boatwright's question related to jurisdiction? Because the cases are legion, that entitlement is not enough to open the door to the appellate court, and there has been no finding on amount here. So do we have jurisdiction to even consider this?
Well, I will tell you that as Judge Boatwright's first few words came out of his mouth, I anticipated that was where he was heading, and I acknowledge it is not a matter that we addressed in our briefs, and it is certainly, as a jurisdictional issue, a matter that this court is within its power to raise, and we recognize, and I do acknowledge, I'm familiar with the case law that says it is only upon the determination and setting of the amount of fees at which time it is appropriate for the appellate court to determine and rule on the issue of attorney's fees. And certainly, with that perspective, I could understand the court addressing that matter in that
Well,
fashion.
counsel, let me ask you this question. Let's assume, as has been discussed, the case law says you have to have entitlement and amount to have jurisdiction. Okay, so under that view, we don't have jurisdiction, but did the trial court have jurisdiction to determine that the facts before him, the case before him, was such that he could rule that indeed someone can seek attorney's fees? I'm not going to say who prevailed at this point, but I'm concluding as a matter of law that that provision, Section 10 of the NDA, provides for attorney's fees to the prevailing party in this case. In other words, it's basically making a declaration of law that this clause applies to the facts of this case. It's another day for entitlement, it's another day for amount. You follow what I'm saying?
Respectfully, I'm not sure, because I think what the trial court did was, in fact, determine entitlement.
Well, that's right, yeah, that you're entitled to fees.
Correct.
But what I'm saying is that they're saying, their argument is that even before you get there, this doesn't even apply to the situation. And this clause doesn't even apply to it.
Understood.
I haven't read the judge's order that carefully on this issue, but did the judge have to necessarily conclude as a first step that 10 A and B actually do apply in this case?
The court necessarily did so by determining entitlement.
Right, that's my point.
Yes. If that's what you're saying, I agree. And necessarily, the court had to have concluded that, because the basis for our motion or our request for the assessment of fees was, in fact, paragraph 10B of this NDA. So
You'd like us to rule that you're entitled to fees at this point, right? We don't think we can do that. But can we, as the panel today, say that the trial court was correct, maybe implicitly because it granted fees, to say that this provision applies in this case?
I guess if you can't determine that we are entitled, then I don't see how you have jurisdiction to determine that we're not entitled. I think it's just the reverse of the same issue. And if that issue is only right after the setting of the amount of fees, that would be when it would be right for this court to address that issue, if that's your
Right, because if it's
perspective.
remanded back down to the trial court now to do entitlement and amount, then, well, I guess it would go back if entitlement's already been determined. So
Correct.
So it really doesn't matter.
Correct.
But they will then have an appeal from the final order there, where they'll argue again, as they've argued today, that Section 10 doesn't apply.
But necessarily, if indeed the court defers ruling on that issue now on the basis of jurisdiction, then I certainly acknowledge that when the fee amount is set so that a final judgment of fees is awarded, then consistent with your ruling that you can't determine that issue now, then both the issues of entitlement and amount would be appropriate to be considered if there is indeed a next appeal.
Right.
Yes. A couple other points, and starting first with the issue that Mr. Riemenschneider addressed with respect to the waiver issue, that is whether the affirmative defense was appropriately pled or not. First of all, in our brief, and we certainly identify it, not only was there an original affirmative defense which said the publication to CUC was done in circumstances that make the publication of that communication qualifiably privileged and the privilege was not abused. So we very clearly put them on notice that we were asserting that there was a qualified privilege. The fact that Thomas was cited in that affirmative defense is not a limitation. If you look at the Thomas opinion, it discusses qualified privilege generally, the scope of it, the requirements of it, etc. So that the issue was certainly framed and pled for that reason. In addition, there was an amended answer filed in which amended affirmative defenses were pled and added, one of which expressly says, and it's just a part of it, it's page 14 of our brief, that it expressly says made pre-suit was a preliminary step in the institution of the counterclaim filed by the physician defendants. So there was a very specific affirmative defense added, which expressly referred to the qualified privilege arising because it was a statement made pre-suit in relation to anticipated litigation.
And that amended affirmative defense, or the second answer, was still previous to the court's ruling on the motion for summary judgment.
Yes.
So that it would be your position, the appellee's position, that put them on full notice what was going to be advanced in front of the trial court.
Yes, and further with respect to full notice, our motion for summary judgment went into great detail about the litigation privilege. And indeed, if you take a look at the response to that motion for summary judgment, that issue was addressed on the merits by Ocala Hart. They didn't raise any issue of waiver. They didn't raise any issue that hadn't been pled. Instead, they literally addressed the issue on the merits, which again they did at the hearing on the motion for summary judgment itself. The court ruled granted summary judgment. They didn't seek rehearing. They didn't raise the issue then. And instead, when we submitted a proposed final judgment and the court entertained comment on that final judgment, counsel at that point, for the first time, raised this issue of failure to have pled it, which we maintain pursuant to this court's opinion in the Reddy case, which we cited, was a waiver because he had addressed the issue on the merits without complaining about the alleged failure to have pled that.
So we all understand, and I believe you've been clear, counsel, but so it's pleaded in the answer would be your position. It's advanced in the motion for summary judgment. It's included in the response to the motion for summary judgment. It's argued at the summary judgment hearing, and there's no motion for rehearing related to the summary judgment hearing, including that argument.
Exactly, Your Honor.
And it's only when a proposed order is sent to
The proposed final judgment itself, meaning the order granting summary judgment is entered. And then it's only when the court, we filed a motion for the entry of final judgment, it was at that point that the court said, do you have any comments with respect to the final judgment? And rather than addressing the terms of the final judgment or anything else, that's when for the first time, Ocala Hart raises this issue of that they didn't raise this privilege as an affirmative defense. And at that point, and the Reddy case expressly says it, when they literally litigated the issue without raising our alleged failure to have raised it, they themselves waived by having failed to do so.
Can I ask you about the malice issue under defamation? Typically, so the judge ruled on that issue. Is malice usually, because it has an intent element to it, isn't that usually reserved for the jury to determine that issue? So is it proper for the judge to rule on that issue at this point?
It absolutely is. And if you take a look at the Nodar case, the Supreme Court case, which goes to length in the discussion and explanation of what the qualified privilege is, in that case, the court did two things. First, they determined that whether there is a qualified privilege when the facts are clear is a question of law to be determined by the court. And in Nodar, they further said that based on the factual record of that case, which was the Broward County teacher issue, but that based on the facts of that case, they said the trial court should have directed a verdict and could have directed a verdict in favor of the defendant because there was no evidence that supported the requirement of express malice. And in fact, the Nodar court, the Supreme Court determined itself. They didn't remand saying, trial court, you have to determine whether there is evidence of express malice or not. The Nodar court determined itself that based upon this record, based upon this evidence, as a matter of law, this does not elevate itself to the requirements of express malice. And in doing that, they looked at two things. One was the words themselves. And they looked at the words that were the alleged defamation, and they said, do they elevate to such a level that it could be determined as a matter of fact that this does qualify as a defamation? And they compared it to other cases in which there were much more horrific words expressed, and the court determined as a matter of law, these words were not of the type that are evidence of
Was there
express
anything
malice.
else here other than the email that has been alleged to be malicious?
Not at all. And in fact, Your Honor,
It's just been that, the email.
it is.
Right.
And with respect to that email, what's really important is the following. And we'll talk about the email generically, but when the court reads the email, Ocala Hart's name is not mentioned anywhere in this email. The invoices that were attached, Ocala Hart's name was redacted from it, and all the email says is, I am currently auditing the doctor's office in Ocala for fraudulent activity. Invoices have been found that have been falsely created and paid for various vendors. It doesn't say Ocala Hart did anything. It doesn't say Ocala Hart modified invoices. There is no accusation made at all that Ocala Hart did anything wrong. There's no statement that Ocala Hart committed any fraud. And that's significant because, as Your Honor asked, in Nodar, looking at this language, the trial court could, as a matter of law, determine that the language that is alleged to have been defamatory does not show the express malice that is required to overcome the qualified privilege. Because again, the express malice requires that the primary motivation is to cause injury to Ocala Hart. And in that regard, in addition to that, the evidence that was in the record included testimony from Dr. Dressen, the president of Ocala Hart, in which, and he said the following, when asked in his deposition about this issue of ill will. Question, paragraph 16 says, in an attempt to destroy the good name and goodwill of Ocala Hart, do you believe that Ms. Kitos was trying to destroy the good name or goodwill of Ocala Hart and its doctors? Answer, yeah. Question, you do. Answer, yes, I do. Well, that wasn't her primary objective, maybe. Her primary objective was to find fraudulent activity. So and that's literally as if Dr. Dressen had read these cases as to what is the definition of express malice, and the requirement being that the primary motive has to be ill will and bad faith. Dr. Dressen testified that wasn't her primary motive. And in fact, Ocala Hart acknowledged that as well in their initial brief in this case. At page 5, they say the following. According to Kitos, she needed to verify if CUC's invoices were in fact CUC's. Kitos' actual motive was to learn if someone at Ocala Hart was creating false invoices to steal money from the Prashad Group.
And how quickly did you find the answer to that question?
My understanding is that, as counsel said, the CUC representative who received these emails, based on the dates of them, determined that it was Ocala Hart's and communicated her receipt of that email to Ocala Hart. And it was, I think, soon thereafter that it was determined that, in fact, these were the CUC legitimate invoices. And as there was an affidavit we submitted in support of summary judgment from the CUC representative, the owner, who said, I got these. I went the next day and continued to do business with Ocala Hart. This had no impact whatsoever on my relationship with Ocala Hart, and she just continued to work. And in that regard, by the way, as well, in terms of this issue of the proprietary or confidential nature of these invoices, when they were produced, they were not marked as confidential. And what the NDA, the non-disclosure agreement, says is, notwithstanding the foregoing, information shall be deemed proprietary information if it is reasonably apparent based on its form or content that OHC intends to treat the information as confidential. Meaning, it's an objective standard. if they don't mark a document as proprietary, the question is, if you see that document, if you look at the document itself, is there anything about the document that screams out and tells you, O'Callaghan wants this to be kept as proprietary confidential?
Mr. Levin, you're in the 3 minutes. I don't know if you want to defer the remainder of your time to Mr. Romanek.
Mr. Romanek is happily ceded it to me, and thank you for bringing that to our
You
attention.
may proceed.
The point is that, as the trial court determined, these were invoices that were sent to the company that issued those invoices, and that looking at those invoices and sending them to the entity that created them, it was not reasonably apparent based on the form or content of the invoices that O'Callaghan had any intention to maintain them as confidential, even if in their heart of hearts they wanted to.
Was there any communication from the clinic to your clients saying, oh, we just got this email, it appears to us to be defamatory, we ask that you correct the record here and make it clear that this is just an inquiry, not an allegation of fraud?
I acknowledge that I'm not certain. I don't want to misrepresent to the court.
If you don't know, you don't know.
I don't, and I'm trying to think back, and I can tell you I have no recollection of there being anything in the record in that
What
regard.
about what's the status of the counterclaims?
Those matters have been tried, and a judgment has been entered. And
Has it been appealed, or is it?
it's this afternoon, the notice of appeal shall be filed. Otherwise, though, Your Honors, I'm just trying to see if there was anything else that was addressed, and certainly if the court has any questions, I'm happy to address them. The trial court also, certainly by citing one case with respect to the issue of qualified privilege, that case also addresses and talks about what a qualified privilege is, and as the courts acknowledged, not only was there the lawsuit pending with respect to the records, but there had, before Ms. Quito sent this email, a few months before, a letter had been sent to O'Callaghan advising them if the issues that were the subject of these disputes were not resolved, there would be litigation. So there also was the presence of anticipated litigation as well, and that's precisely the purpose for which Ms. Quito sent that email, was to get information that related to that litigation and the claims that were served. Thank you, Your Honor.
Thank you, Mr. Levin. Rebuttal?
Yes, sir. Quickly, the Nodar case. Your Honor asked about express malice. Express malice is clearly a factual issue, and no one in the world says, I'm going to destroy you, and that is the issue. You have to look at the totality of the circumstances to determine if there's express malice. Now, Nodar says, and counsel did not bring this up, and I'll quote, examples of cases where the false and defamatory words themselves were so extreme as to intrinsically show express malice. And they cite the Loeb case, and they say the reference to evil conduct or low moral character or disgrace or a troublemaker was not respectable, has been compelled to leave Chicago. In that particular case, the court found that those terms by themselves were evidence of express malice. And so we have a situation where the person who received this email knew it was O'Callaghan immediately upon receiving the documents, because the documents themselves made it clear the dates that she works on Tuesdays. This was O'Callaghan, so there was nothing hidden about O'Callaghan. She knew exactly it was O'Callaghan that they were talking about. And she says that there were false invoices. We say in page 25 of our brief, our initial brief, that there were a number of things that happened, including the fact that all of the representations that she made in the email were in fact false. So she was making false statements that she knew were false in the actual email itself. And because they were false statements, and really no one has rebutted this, because there were false statements, because she used inflammatory language, that was evidence of express malice that should have gone to the trier of fact. Thank you, Your Honor.
Thank you. Thank you all. Ladies and gentlemen, as I indicated on the front end, we're going to take a short break. And when we come back, we'll resume with the last two oral arguments. We will be in recess until 9:55.